So in some of the recent court rulings against Donald Trump, something of a roadmap is emerging. A roadmap of how the Department of Justice can and should go about indicting Donald Trump for the insurrection. Let's talk about that. Because justice matters. Hey all, Glenn Kirshner here. So I want to discuss two things I read today that in combination make a really powerful argument for how and why Donald Trump must be prosecuted for inciting the insurrection. The first is an article that ran in Salon, authored by a former federal prosecutor named Dennis Aftergut, that discusses Judge Amit Mehta, the federal district court judge here in D.C., ruling that the suit against Trump for inciting the insurrection will proceed to discovery. Judge Mehta refused to dismiss that lawsuit against Donald Trump. And then the second thing I want to talk about is what's called a prosecution memo. Now, a prosecution memo is something that we prosecutors are required to draft before we ask a grand jury to indict someone. And these memos are lengthy affairs. We set out all the facts, all the evidence, all the applicable law, and the legal analysis before we reach a conclusion that yes, the right thing to do is to ask the grand jury to indict someone for one or more federal crimes. The prosecution memo that I'm going to discuss was authored by former United States Attorney Barb McQuade. You very likely have seen Barb giving her expert legal analysis on air in recent years. Barb is a real voice of legal authority. So let's start with the article authored by former federal prosecutor Dennis Aftergut. Now I'm just going to highlight a few passages from the article, but I'll put a link to the article in the description of this video. The title: A district judge just gave DOJ a precise rationale for prosecuting Trump. And that article begins, last week, the federal district court for the District of Columbia broke new ground in the law of the presidency. It ruled for the first time in the country's history that a former commander-in-chief may be held liable in a civil lawsuit for the harm caused by his conduct while he served. In Thompson versus Trump, Judge Amit Mehta rejected former President Donald Trump's bid to dismiss 3 consolidated lawsuits brought by 11 congressional representatives and 2 Capitol policemen to hold Trump accountable for his role in the January 6th insurrection. The district court did something with implications for a potential prosecution of Trump. The court concluded that one could plausibly read his words on January 6th as directed to inciting or producing imminent lawless action and were likely to produce such action. The quotation states the Supreme Court's test in Brandenburg versus Ohio for words unprotected by the First Amendment. No court has ever so condemned a president's speech. Judge Mehta heavily emphasized the context that supported his conclusion. Before January 6th, the president and others had created an air of distrust and anger among his supporters by creating the false narrative that the election literally was stolen. In the weeks after the election, some had made threats against state election officials, and others clashed with police. Against this backdrop, it is reasonable to infer that the president would have known that some supporters viewed his invitation to D.C. on January 6th as a call to action. His words stoked an already inflamed crowd. The judge has put in writing the precise rationale for the Justice Department breaking a tradition of not prosecuting a former president. his seeking to overturn an election and fomenting lawlessness are completely beyond prior American experience. So the author makes the important point that even though Judge Mehta's ruling is in the context of a civil lawsuit, it does provide DOJ something of a roadmap to prosecuting Donald Trump criminally. And if Judge Mehta's ruling is something of a roadmap to prosecuting Trump, let's turn to Barb McQuade's prosecution memo. Because after reading that lengthy memo, it's about 18 or 20 pages long, and I will put a link to that memo in the description of this video as well. After reading it, I kind of feel like you could just type "Road to Indicting Trump" into a GPS and Barb's memo would pop up. Now, I stumbled upon the memo today when I was going to Barb McQuade's Twitter feed to catch up on what Barb was saying, and she tweeted this out. If DOJ were considering charging Trump, here's what a prosecution memo might look like. I wrote this based on public information focused solely on Trump's efforts to pressure Pence to overturn the election. The only thing riskier than charging Donald Trump is not charging Donald Trump. And here are just a few short passages from Barb McQuade's prosecution memo. Public reporting, including governmental documents, indicate that following the 2020 election, President Donald Trump exerted pressure on Vice President Mike Pence to reject the certificates of electors from certain states won by Joe Biden and declare Trump the winner. Under the 12th Amendment to the Constitution and the Electoral Count Act, the Vice President, as President of the Senate, is responsible for opening the certificates and counting the votes on the 6th day of January following a presidential election. While facts are still being uncovered, public reporting and some of the evidence obtained by the Select Committee to investigate the January 6th attack on the United States Capitol show a relentless campaign to coerce Pence into helping Trump retain the presidency. This effort may have been only one of many schemes within a larger strategy to overturn the election. Looking solely at this aspect of the strategy, at least 2 federal criminal statutes may have been violated in this episode alone: conspiracy to defraud the United States and obstruction of an official proceeding. And then Barb goes on to talk about the standards that apply when we are evaluating whether to indict somebody or not. There's what's called the legal prong and the discretionary prong. The legal prong states, the attorney for the government should commence or recommend federal prosecution if he or she believes that the person's conduct constitutes a federal offense and that the admissible evidence will probably be sufficient to obtain and sustain a conviction. Check. That's my editorial addition. That wasn't in Barb's memo. And then I'm going to turn right to the end of the memo because she pretty powerfully conveys what's at stake. A final factor would need to be considered that is absent in most cases: whether the country would be best served by a criminal prosecution. On the one hand, a substantial federal interest is served by prosecuting a leader who attempted to overturn an election. On the other hand, criminal charges against Trump could have a dangerously divisive effect on the country. Trump's unrelenting rhetoric about a stolen election no doubt contributed to the violent response that occurred on January 6th. DOJ would need to consider the backlash that would likely follow the filing of criminal charges against him. Violent protests and civil unrest should be expected. We might even anticipate loss of life. The other potential negative consequence that would need to be considered would be an acquittal, a not guilty verdict. If Trump were charged and acquitted at trial, then he and his violent extremist followers would be emboldened. A sober and clear-eyed assessment of prosecution must consider that charging Trump criminally could have profoundly negative consequences for our country. The only thing worse would be not charging him. The only thing worse would be not charging him. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.